Welcome back to the deep dive. Today we are stepping into a story that honestly feels like it belongs in a noir thriller, but it's actually one of the most significant legal turning points in mental health history.
It really is.
We're talking about obsession, a confession behind closed doors, a murder, and a court case that, well, it fundamentally broke the seal of confidentiality between a therapist and their patient.
Mhm.
We were digging into Tarasoff v. Regents of the University of California.
It's a massive case. It really forces us to ask a question that sounds simple, but is, incredibly messy.
Right.
If you're a therapist and your patient tells you they're going to kill someone, whose side are you on? Do you protect your patient's secret, or do you protect the unsuspecting victim?
Because we usually think of therapy as this sacred space where you can say anything without consequence. But Tarasoff completely changed the rules, so what's our mission today? How do we take this apart?
Okay, so we're going to follow a very specific map.
Yeah.
First, we have to understand the basic ground rules of negligence, specifically this idea of a duty of care. We have to look at why. Generally, the law lets you just stand by and watch a disaster happen. Then, we'll dissect the special relationship exception. That is the key mechanism here.
The loophole, basically.
Kind of, yeah. Third, we're going to look at the tension between confidentiality and public safety, and we'll use a pretty extreme hypothetical to do it.
Oh.
And finally, we will break down the Tarasoff case itself, element by element, and look at this whole other issue of governmental immunity.
Okay, let's unpack this. Before we even get to the tragedy of Tatiana Tarasoff, we need to understand the legal landscape this all happened in. I think most people assume that if I see someone in danger, I have to help. But that's not actually true, legally speaking, is it?
No, it is not, and this is often a huge shock to people. The foundational question is this: does the law generally require a person to control the conduct of another person, or to warn someone who is in danger?
And the answer is...
The general rule under common law is a hard no. One person owes no duty to control the conduct of another, nor to warn those endangered by such conduct.
That is just wildly counterintuitive. You're telling me that if I'm standing on a dock and I see a stranger drowning, and there's a life preserver right at my feet, legally, I can just keep eating my sandwich and watch them drown.
Morally, you're a monster.
Right.
But legally, yes,
Yeah.
you are in the clear. American tort law is built on a very strong philosophy of individualism. Unless you caused the danger or have a specific relationship to the situation, you just don't have a legal obligation to be a good Samaritan.
Okay, that is cold. But obviously, society can't function if everyone's just watching everyone else get hurt. So there has to be a hook, a way to create liability. Where does the exception come from?
The exception comes from something called the Restatement Second of Torts. Now, for those not in law school, think of the restatement as like the ultimate encyclopedia of legal wisdom. It summarizes the common law.
It's not a law, but it's what courts look to.
Exactly. And the restatement says a duty of care arises only if a special relationship exists.
A special relationship.
Mm.
That sounds vague. What does that actually look like?
It has to fall into one of two buckets. Either A, there's a special relationship between the actor, so in our case, the therapist, and the dangerous person, which imposes a duty to control them.
Right.
Or B, there's a relationship between the actor and the victim, which gives them a right to protection. Without one of those links, the no-duty rule stands firm.
So a random person on the street, no link, no duty. A therapist, though, has that link to the dangerous person. Now, before we apply this, I want to play devil's advocate for a second. The defense brought up a really strong argument about psychiatry itself. They basically said, look, we aren't fortune tellers.
A prediction defense.
Right. Psychiatry isn't an exact science. If therapists are often wrong and tend to overpredict violence just to be safe, how can we possibly hold them liable for failing to predict it?
And that's a very valid concern. If you hold therapists liable, they might just start locking everyone up the moment they express a dark thought. But the court rejected this as a complete shield for liability. They acknowledged that forecasting violence is hard. But the standard isn't perfect performance or infallible prediction. You don't have to be a psychic.
So what is the measuring stick then?
The standard is that reasonable degree of skill, knowledge, and care ordinarily possessed by members of that professional specialty. Basically, did you act like a competent professional?
So you're judged against your peers, not against a crystal ball.
That's it, exactly. If a reasonable therapist would have seen the red flags, you don't get a pass just because the science is difficult.
That makes a lot of sense. Now, to really drive this home, this tension between keeping secrets and saving lives, the source material mentions a hypothetical that just it stops you in your tracks.
Right.
The presidential assassin scenario.
Right. So this is designed to test your commitment to confidentiality. The court poses this question. Imagine a therapist has a patient. That patient reveals, in total confidence, that they have a concrete plan to assassinate the President of the United States.
Wow.
Does a therapist have a duty to break confidentiality and warn the authorities?
I mean, okay, that puts it in perspective. If I know someone is about to shoot the president, screw confidentiality, right? I'm calling the Secret Service immediately. Is that the logic the court is using?
That is precisely the logic.
Okay.
The court argues that in that scenario, the therapist must warn. And their reasoning is purely utilitarian. They say, and I'm quoting here, the risk that unnecessary warnings may be given is a reasonable price to pay for the lives of possible victims.
Unnecessary warnings are a reasonable price to pay. That is the core philosophy right there. Okay. We have the doctrine. We understand the stakes. Let's move to the main event. Let's analyze Tarasoff v. Regents of the University of California. I'm going to lay out the facts because the story is just, it's tragic.
Go ahead.
So the central figure is a man named Prosenjit Poddar. He was a graduate student at UC Berkeley in the late 60s. He meets a young woman, Tatiana Tarasoff, at a folk dancing class. They see each other a bit, share a New Year's Eve kiss, and Poddar interprets this as a very serious engagement.
But she doesn't.
She does not. She tells him she's not interested. And Poddar just spirals. He becomes depressed, obsessive, stops going to class.
And this is where he seeks help.
Right. In August of '69, he becomes a voluntary outpatient at the university hospital. He starts seeing a psychologist, Dr. Lawrence Moore. And in these sessions, Poddar confides that he intends to kill Tatiana. He doesn't always name her, but it's clear who he's talking about.
And this is crucial. Dr. Moore didn't just brush this off.
No, not at all. He took it very seriously. He consulted with 2 other doctors, and they all decided Poddar was dangerous and should be committed for observation. Moore actually notified the campus police and sent a formal letter requesting they detain Poddar.
So the system is working so far. The threat is identified. Police are called.
Yes, the police detain Poddar. But, and here's the big twist, Poddar appears completely rational to them. He's calm, he's collected, he promises to stay away from Tatiana. So the police release him.
And then the administration gets involved.
Exactly. Dr. Pallison, the director of psychiatry, finds out, and he shuts it all down. He orders Moore's letter to be returned, he orders the therapy notes to be destroyed, and he directs that no further action be taken.
And Tatiana has no idea this is happening.
None. She's in Brazil on vacation. She comes back to the U.S. completely unaware. On October 27, 1969, Poddar goes to her house and kills her. The crucial, heartbreaking fact is that no one, not the doctors, not the police, not the university, ever warned Tatiana or her parents that she was in mortal danger.
It's just a complete systemic failure. The information was there to save her, but it was just siloed.
So the family sues, and the case goes all the way to the California Supreme Court. What was the core legal issue the court had to decide here?
The issue is, does a psychotherapist who determines, or should have determined, that a patient presents a serious danger of violence to someone else, do they owe a duty of reasonable care to protect that intended victim, even without a direct relationship to them?
Okay, so that's the question. But how did the court actually tackle it? What rule of law did they apply? And could you break it down into its testable elements for us?
Sure. The court applied the special relationship exception to that no-duty rule we talked about. They came up with a rule that has 3 distinct elements. First, the existence of a special relationship.
Okay.
The defendant has to be in a special relationship with either the dangerous person or the victim. Second, the determination of danger, which is about foreseeability. The therapist determines, or really should determine, that the patient is a serious danger.
Got it.
And third, the duty to protect. The therapist has to exercise reasonable care to protect the intended victim.
Thank you. That gives us our roadmap. Now, let's do the court's elemental analysis. Let's walk through this step by step. How did the court apply that first element, the special relationship?
So the sub-issue there was, does a therapist-patient bond even qualify as a special relationship that creates a duty to outsiders?
Which was the defense's whole argument.
Exactly. But the sub-rule the court used is that, yes, the therapist-patient relationship supports these kinds of duties. They used an analogy. If a doctor knows a patient might have a seizure while driving, that doctor's duty extends to the public who might get hit.
That makes sense.
So in applying this to the facts, Potter was clearly a patient of Dr. Moore. That was established. So the conclusion on that element was simple. Element met. The relationship was there.
Understood. The relationship is the bridge. Now, what about the second element, the determination of danger? This seems trickier because of that we can't predict the future argument we talked about.
You'd think so, but this is where the specific facts of the case
Yeah.
they really hurt the defense. The sub-issue is, did the therapist actually predict the violence?
And they did.
They absolutely did. The court found that the therapist did, in fact, predict Potter would kill Tatiana. This wasn't a guess. Dr. Moore explicitly requested commitment. He notified the police. So, the conclusion here is that the element is easily met. The court said this wasn't a failure to predict. It was a failure to act effectively on a prediction they had already made.
That distinction is so important. It's not that they missed the signs. They saw the signs and then buried them. Okay, now for the critical third element, the duty to protect. This is the big clash, right? How did the court analyze the obligation to warn versus the concept of patient privilege?
This is the heavyweight fight of the whole case. The sub-issue is, does the public interest in safety outweigh the public interest in patient privacy? The therapists argue that confidentiality is, absolute.
Right, the bedrock of therapy.
But the court looked at the law, specifically Evidence Code Section 124. And the sub-rule there is that there's an explicit exception to privilege if the patient is dangerous and disclosure is necessary to prevent that danger.
So the exception was already on the books.
It was. So in applying this, the court just weighed our risk-infested society against the need for effective treatment. They basically concluded that hiding the knowledge of a lethal patient serves no societal interest at all.
And the element was met.
The element was met, and this leads to the most famous line from the whole opinion. The protective privilege ends where the public peril begins.
The protective privilege ends where the public peril begins.
That's going on a t-shirt. So after analyzing all three of those elements, what was the court's final conclusion?
The court held that the plaintiffs can state a cause of action against the therapist for negligent failure to protect Tatiana. They overturned the demurrer, which is just a fancy way of saying they let the case go forward.
So the family got their day in court.
They did, but with a major caveat. The court allowed the claim for failure to warn to proceed. But the claim about failing to confine Potter, that was barred by governmental immunity, and so was the claim against the police. Okay, you just opened a new door there. Governmental immunity. That explains why the police weren't held liable even though they released him. Let's dig into that secondary issue. First, what are the key facts about the defendant's employment?
The key fact is that all the defendants, the therapists, the police, they're employees of the University of California. The UC system is a public entity, so they're government employees.
And what was the core legal issue on that point?
The issue was whether the therapists were immune from liability under a government code section that protects public employees for acts that result from the exercise of discretion.
Discretion? That seems really vague. I use discretion deciding what to eat for lunch. What rule of law did the court apply to nail down what discretion means here?
They used a rule from a case called Johnson v. State of California. This rule makes a distinction between two types of decisions: basic policy decisions and ministerial administrative acts.
Okay, what's the difference?
Immunity applies only to the basic policy decisions, the big picture planning level stuff. It does not apply to the ministerial acts, which are just the operational day-to-day execution of those plans.
So deciding to build a highway is policy.
Right. You can't sue them for that.
But forgetting to put up a cone next to a hole on that highway is ministerial.
Exactly. That's the ground level execution. You fail at that, you can be sued. No immunity for that kind of carelessness.
That clarifies it perfectly. Okay, so now for the court's elemental analysis. How did they apply this distinction to the therapists failing to warn Tatiana?
Well, the court compared it to a parole officer deciding whether to warn foster parents about a violent kid. They reasoned that the decision not to warn is at the lowest ministerial rung of official action.
It's not a big policy choice.
Not at all. In applying the rule, they said that deciding to pick up the phone and warn someone isn't some complex policy debate. It's just a standard professional decision. Therefore, the conclusion is that the decision to warn is not a basic policy decision. And because of that, the therapists are not immune for failing to warn.
So you can't hide behind a government badge for a low-level decision like failing to pick up the phone. That's a huge distinction. Okay, this has been fascinating. We've gone through the doctrine, the tragedy, the immunity. But for our listeners, especially the law students, we need to synthesize this. Can you take all these rules from Tarasoff and turn them into a step-by-step diagnostic checklist for an exam?
Absolutely.
Yeah.
Okay, pull out your mental notepads. Here is your Tarasoff duty checklist. Run this sequence every time you see a potential threat in a therapeutic context.
Mm,
Step 1. Identify the actor. Is the defendant a professional with a special relationship to the dangerous person? Usually a therapist-patient bond. If the answer is no, stop. The general rule of no duty applies. If yes, go to Step 2. Step 2. Analyze foreseeability. Did the therapist determine, or should they have reasonably determined, that the patient presented a serious danger of violence? Look for specific threats.
makes sense.
Step 3. Identify the victim. Is there a foreseeable, identifiable victim? You generally need a target, not just a vague threat to kill everyone.
Right, a specific person.
Step 4. Evaluate conduct. The breach. Did the therapist take reasonable steps to protect the victim? Check the actions. Did they warn the victim? Warn the family? Notify police? And remember, notifying police alone might not be enough.
The duty is to protect, not just to report.
Exactly. And finally, Step 5. Check for defenses. Privilege. Does safety outweigh privacy? If the danger is serious, yes. Immunity. Was the failure to warn a basic policy decision? Almost certainly no, it's ministerial.
So what does this all mean? When you boil it down, the big takeaway here seems to be that in our society, even the deepest secrets have their limits.
That's it. The court used the phrase, risk-invested society. In that kind of world, professional confidentiality is not absolute. The safety of the public, and specifically the safety of a targeted victim, trumps the privacy of the patient. The law effectively deputizes therapists as a first line of defense.
It really changes how you think about the confessional nature of therapy. It makes the therapist a guardian of the public, not just the patient.
It does. And I want to leave you with a provocative thought to mull over. The court established that this liability exists, that safety is paramount. But ask yourself this, does this rule actually make society safer? Or does it discourage dangerous people from seeking therapy in the first place? I mean, if Prosenjit Podar knew that his words would be immediately reported to the police and to the girl he was obsessed with, would he have ever spoken to Dr. Moore at all? And if he stays silent, does he just commit the murder sooner, without anyone ever having a chance to stop him?
That is the ultimate tension, safety versus silence. If you mandate warning, you might destroy the very treatment that could prevent the violence. A haunting thought to end on. Class dismissed.